Parental rights versus student privacy. This fundamental tension is tearing apart school communities across America, with protests erupting in multiple districts as California's new law becomes the flashpoint for our most heated culture war. The problem? Most people forming strong opinions haven't actually read the legislation. Today, I'll peel back the layers of viral claims and reveal the complex reality behind the law, comparing 5 major myths with legal facts. By examining what the law really says versus social media narratives, you'll see how this issue defies simple categorization and why these oversimplifications are failing both our students and families. Have you ever wondered why the headlines about AB 1955 seem so misleading? California's AB 1955, also known as the SAFETY Act, has generated controversy not for what it actually contains, but for what people believe it contains. At its core, this law prohibits school districts from creating or enforcing policies that would require staff to disclose information about a student's sexual orientation, gender identity, or gender expression to anyone, including parents, without the student's consent. This is a specific protection around particular types of sensitive information, similar to how a student's personal diary might remain private even in school settings. When you look at the actual text, the law makes an important distinction that many viral social media posts miss. It doesn't prevent schools from sharing academic records, attendance information, or behavioral issues with parents. Those parental rights remain fully intact. What it protects is information specifically related to how a student identifies in terms of gender or sexuality. This distinction matters because much of the outrage stems from conflating notification with disclosure. The law doesn't prevent schools from notifying parents about their child's education generally. It prevents mandatory disclosure of specific sensitive information that could potentially put some students at risk. In practice, schools implementing AB 1955 are developing policies that respect students' chosen names and pronouns while creating confidentiality plans that navigate when and how to involve parents. This creates safety nets for vulnerable students while maintaining the educational partnership with families. The law creates a clear boundary between social transition and medical transition. Any medical interventions related to gender, hormone therapy, surgeries, or other medical treatments still absolutely require parental consent. The law only addresses social aspects like using different names or pronouns in school settings. When viewed in context, AB 1955 extends privacy frameworks that already protect students in various ways. Schools have long maintained certain privacy boundaries to protect students in sensitive situations, whether related to counseling, abuse reporting, or other confidential matters. The controversy stems from a fundamental question about where the boundaries between parental authority and student autonomy should lie. For some, any limit on parental information feels like an infringement of their rights. For others, these protections represent necessary safeguards for vulnerable youth. While the fight over California's law captivates the headlines today, the legal system has been wrestling with these tensions for years. In fact, real judges are making binding decisions right now that affect millions of families across America. The landmark case of Foote versus Ludlow School Committee forced the courts to draw a line between parental authority and student privacy, with surprising results that few people realize. In 2025, this federal appeals court upheld a Massachusetts school district's policy allowing students to decide whether their parents should be informed about their gender identity at school. The judges balanced two fundamental principles: parents' constitutional right to direct their children's upbringing versus students' rights to privacy and equal protection. This ruling directly determined whether schools could honor students' requests for privacy about their gender identity when speaking with parents. This legal balancing act isn't just theoretical. It affects real students in real schools. The court acknowledged parental rights while determining these rights do not extend to controlling school policies regarding student privacy. Schools could implement policies prioritizing student confidentiality in specific circumstances. Why would schools consider keeping information from parents? According to recent studies, transgender and non-binary youth face alarmingly high rates of mental health challenges, including anxiety, depression, and suicidal thoughts. The data reveals something critical. Supportive environments that affirm a student's gender identity significantly lower these risks, with youth from supportive families experiencing substantially better outcomes. In practice, school administrators have direct conversations with students about their preferences regarding parental communication. Many districts develop individualized confidentiality plans that outline how and when parents might be informed, balancing privacy concerns with family involvement. The compelling state interest standard used by courts works like a protective threshold. Imagine a scale where parental authority sits on one side and a student's safety on the other. Only when safety concerns become heavy enough does the scale tip toward intervention. With such profound consequences for families and students alike, can we find approaches that recognize the irreplaceable role of families while acknowledging that some students genuinely need additional protection? As we search for that middle path between parental rights and student protection, we need to confront an uncomfortable reality. Much of the public debate is built on claims that don't match what's actually happening in classrooms. The most viral social media posts about California's law have transformed legitimate policy questions into exaggerated scenarios that fuel outrage rather than understanding. Let's examine these claims like optical illusions. What appears one way at first glance reveals something entirely different upon closer inspection. Take the claim about elimination of parental rights. Headlines shout, "Parents completely shut out of their children's education." The reality? Parents maintain access to academic records, grades, and all other educational information. The law creates a specific carve-out only for gender identity information, while parents remain deeply involved in everything else. Another common misconception suggests teachers are forced to lie to parents. This oversimplifies how schools actually handle these sensitive situations. Rather than mandating deception, most schools develop individualized confidentiality plans with students, focusing on creating pathways to communication, not barriers to it. Social media also circulates the myth that kids are changing genders on a whim. Research on adolescent development tells a different story. Many transgender youth engage in significant reflection about their identities long before seeking recognition at school. These represent deeply personal realizations that often follow months or years of internal questioning. The claim that California has invented radical new policy approaches misunderstands educational history. These privacy protections build upon existing frameworks like FERPA, which already limits parental access to certain sensitive student information. The principles in AB 1955 are evolutionary extensions of privacy considerations established decades ago. Perhaps most compelling is what research reveals about these policies. Studies consistently show that supportive school environments, including respecting students' chosen names and pronouns, correlate with lower rates of depression and suicidal ideation among transgender students. Organizations like the ACLU emphasize that forced outing endangers transgender students, recognizing that while family support is ideal, not all home environments provide that safety. Looking beyond the political battlegrounds, what emerges from this controversy is a fundamental challenge in our education system, finding that delicate balance where vulnerable students feel safe while honoring the crucial role parents play in their children's lives. The most promising approach comes from educators who create individualized plans with transgender students that address parental involvement case by case. This isn't about political divisions, it's recognizing that no single policy fits every situation. The path forward lies in thoughtful collaboration between schools, families, and communities. When we see beyond rigid positions, we discover solutions that minimize harm while supporting students navigating gender identity in diverse family contexts. What matters most isn't winning an argument, but creating environments where all children can thrive.